Well, we will go ahead and get started. I want to thank the members of the Judiciary Committee who are here in person, all two of us, and those members who are with us online. We have 9 bills on the calendar today, so we have a very busy day ahead. I want to begin by recognizing Judge Goslin, who is with us on Zoom today, and appreciate her being with us remotely. Thanks for being here, Judge. And we also have Judge Kell, who is here in person in the hallway here today. And we always appreciate our Superior Court judges who are willing to join us for committee and be a resource if there are any questions for members of the committee. So what we'll do is we will go ahead and get started this time. I know that there are a bunch of committee meetings taking place today, and what we'll have to do is potentially hear a bill, and we may have to hold a vote on it until we get a quorum, but we'll just do what we need to. So at this point in time, I will recognize Representative Carpenter, who is going to present to us House Bill 468.
Thank you.
Gotcha.
You got me now?
Yep.
Thank you, Chairman. Yep, House Bill 468, simple bill. We presented it yesterday in subcommittee, but it basically would say it's a protection for small businesses. We saw during the pandemic that there were certain points of time where large companies were allowed to operate, and a lot of small businesses in certain areas were not. And so what this bill would do would allow that if during the public health emergency that the governor released applicable health and safety measures in a rule or an order, if my business could meet those, then I could continue to operate or be able to operate. And so it's just some concern that I think we've seen it across the nation that certain states have picked winners and losers. And in Georgia, we want to allow people that can operate safely to operate safely. And so it's not a knock on Governor Kemp. He did a tremendous job shepherding us through this COVID-19 pandemic, but it's just saying, in 2026, after he gets reelected, we don't know what we're up against. And so we want to make sure we have these protections in for small businesses.
So what we're talking about here is small businesses who are following all the guidelines that are put out during a pandemic circumstance. They'd be able to continue operating their business following those guidelines that are in place. Is that fair?
Yep, that's exactly right.
And I recall from subcommittee where this bill received a favorable recommendation that the NFIB, Mr. Humphreys, testified their full support for the bill. Is that your understanding?
Absolutely. And I've been in contact with the governor's office as well. And so I think it's something they can support as well. It would cede a little power from the governor's office, but I think it's reasonable amount of to help support small business.
All right. We have some questions. Representative Walensky, what number are you? All right. Yes, sir.
Thank you, Chair. Thank you, Representative, for this great bill. This bill would also be in effect if we had a Democratic governor elected as well. Is that true?
That's exactly right. In 2026. Yes, sir. Yes, sir.
One more question.
Yes, sir.
When's the next governor's election?
I'm hoping the next real governor's election is in 2026 myself. I'm thinking the next one might be a landslide. I'm hoping anyway.
Thank you, Chair. Thank you, Representative.
It's not a political bill, correct?
Yeah, you are correct.
All right. Any other questions for members of the committee?
Yeah.
All right. Seeing none, I will hear a motion. All right. Representative Walensky. Yes, sir. Go ahead.
Motion do pass.
All right, there's a motion to pass from Representative Walensky, HB 468 LC 5000195S. Is there a second? There's a motion and a second. Any discussion, amendments? Hearing none. All those in favor signify by saying aye. Any opposed? All right, passes. It's unanimous and on to rules. If you would please, Representative, just fill out a rules committee form that we can get signed so there's no holdup.
Absolutely. Just go in the office. Thanks.
Yes, sir.
Appreciate
Thank you. Have a good day.
Thanks for getting me in.
Yep.
Mr. Chairman, there's no feature on here for us to raise our hand. So,
Oh, I'm sorry. Did you have a question? Hold up, Representative
well,
Carp.
it passed now, but that's all right. But
Yeah, why don't you go and ask your question, Representative Bruce? I apologize. I didn't know you had a question. Go ahead.
it's moot. The bill passed. I'm not going to, I'll just talk to him about it.
Okay. All right.
Just see me on the floor.
Yeah, if any members are online, just feel free to either use the raise hand or just shout out. You should be able to unmute yourself. So we'll make sure that, and I'll do a better job of making sure that I ask specifically if anybody has any questions online, and also give a chance for responses during vote online. So, all right, very good. So we will now move on to what do I do with it. See, Representative Gullett is here, so we'll go ahead and bring Mr. Gullett forward. And when you're ready, sir, you can present House Bill 334.
Thank you, Mr. Chairman. Thank you, members of the committee. In the summer of 2019, I set out to write an online notarization bill when my county government IT director called me and said, "Why can't we do notaries online? I just saw my doctor online and I haven't been to the bank in years." After a little research, I quickly realized that in the majority of states you can. Having only one legislative session under my belt, as well as being a bit naive, I called him back a few days later and said, "Let's do it." At the time, I had no idea what I was getting into. Turns out the other states that have done this aren't closing attorney states, meaning that you aren't required to use a lawyer to convey real estate. Since beginning this process 2 years ago, I've learned that notarization is an integral part of numerous legal transactions and that attorneys throughout the state have surprisingly strong opinions on the topic. I've also learned how important this measure is to get across the finish line, especially dealing with a pandemic like we're facing with COVID-19. And it really has been interesting and fun, kind of anyways, for an IT guy to get to work with so many of the top legal minds in the state. We've had hours and hours of video calls to hammer out this language and to make sure that we're doing the right thing for Georgians. Our primary objectives were these: create a RON system that will work in practice with enough flexibility to adapt, but firm enough rules in place to protect the integrity of the process. Do absolutely nothing to threaten the role of attorneys in conveying real estate in Georgia. This system has served our state well, and I'm pleased to say that we have put language in this bill that actually strengthens closing attorneys from being threatened by the unlicensed practice of law. For the first time, our real estate attorneys and our citizens are getting an appropriate remedy to seek if consumers are damaged when non-lawyers illegally convey real estate and record the documents here. Number 3, build consensus among 24 specific industries who have interests in the process and wanted to see them protected. I'm pleased to report we have achieved all these goals. We have carefully thought out a bill that was the result of hours and hours of work to find middle ground and make good policy. More than anything, I want to thank the dozens of talented attorneys who gave so generously their time to perfect this bill and make it a reality. All of the parties to this legislation, from the governor's office to the banking and insurance communities to our major business associations in the State Bar of Georgia, support this draft. The only group we're still working on perfecting language with is the Real Estate Closing Attorneys Association, which is a separate organization from the State Bar. Today, they don't have a position on the bill as of when I came in the room. I understand totally the concerns these folks have, and we have partially addressed them with the enhanced UPL language and the surety bond requirements for remote online notaries. However, we're still looking for some language that we can incorporate that would impede bad actors outside of our state from taking away jobs from Georgia lawyers by doing thinly supervised or unsupervised closings in other states. I'm committed to finding an answer here, even though the paths we have taken thus far have resulted in broader title concerns and have not been available to us. We have resolved to keep working on this as we move forward toward the Senate and make the bill as robust as it can be on this front. Georgia has a chance to make legal history here by being the first attorney state to pass a consensus bill to give our citizens the ability to notarize documents without driving to a room and standing in front of a notary. This is convenient, smart, and in many ways much more secure and verifiable than an ink notary. I ask for your favorable consideration, and I'm happy to answer any questions. I appreciate your help getting me across the finish line.
Representative Gullett, how many committee meetings have we had this session about your bill?
Yeah, we've had 3 this session, and we had 2 last year.
All right, so 5 total subcommittee hearings, I guess,
Correct.
just about this piece of legislation.
That's correct.
Well, I want to thank you for your perseverance and hard work on this issue. I won't ask if you had a time machine. If you go back in time, would you still carry this?
I don't
bill?
know. That's telling people, once you put so many hours into it, you want to see it across the finish line. And that's really my motivating factor. I think it is good policy, and I want to get there. But it has been a learning experience and and a humongous challenge at the same time. So
We have a few questions from the committee. Representative Evans.
Thank you, Mr. Chairman. Thank you, Representative Gullett. Yesterday in subcommittee, in that column of no position was the Closing Attorneys Association, but also the realtors. Have they changed their position in
I haven't
any
heard
way?
from the realtors today, but I don't believe that they're going to change their position.
So they're
throughout.
still just neutral on the bill?
That's correct. No
Or
decision.
no position.
That's correct.
Thank you.
Representative Walensky.
Thank you, Chair. To my COVID safe seatmate. Just a question, because I'm a notary and my paralegal is as well. Where does the $25 fee come from? Why do we do $25? I've never understood that. And in all of your hours, did you learn why?
Yeah. So because there's a pretty large technical component of this, and so in order for the notaries to recoup that fee, for one, we have to there's a journaling process for remote notary that doesn't exist for traditional notary, and that journal has to be kept, and the video of the notarial act happening has to be kept for 10 years. So there's a technology cost. So that's why the fee is there to pretty much make that neutral.
Thank you, Chair.
Chairman Scoggins.
Yes, sir. I'm ready to offer up a motion when the committee's ready.
Any other questions for the sponsor? All right, I'll hear that motion now.
Motion do pass.
Motion do pass. Is there a second? All right, any discussion, questions, amendments?
And just so we're clear, I don't know if this is LC 4130007S. It's a substitute bill. I don't know if I mentioned that earlier.
Thank you. Representative Bruce or anyone online, any questions for the sponsor? All right, seeing none, we'll go ahead and call the question now. All those in favor signify by saying aye. Any opposed? All right, hearing none, it passes unanimous and it is on to Rules Committee.
Thank you so much.
Thank you.
Here's the 1 and 2s.
Very good. Thank you.
Deborah Batesmore.
We'll next hear from Representative Washburn. If you'd like to come forward, Representative. We'll hear HB 470 first. And just whenever you're ready.
Thank you, Mr. Chairman. HB 470, we're working from LC 500157. This bill, I was asked to carry this bill by a firm that does big condominium development, multi-use type development, and it came out of when they were arranging financing to begin building these things, they began to have some problems with some attorneys relative to title opinion because of the lack of floor plans for residential units. The problem is at that stage, there are no floor plans because there's no floors and ceilings and nothing for floor plans to be designed for at that stage. So the language is, except for a unit that is an individual residential dwelling intended for single family occupancy, nothing in this code section shall require plans for a unit when the boundaries of the unit are not designated by walls, floors, ceilings, or other physical structures, provided that the boundaries of the unit are depicted on a plat of survey prepared in accordance with subsection A of this code section. Nothing in this code section shall require a separate plat of survey for a subcondominium. So it's just a little cleanup language, and it's good language, and certainly these big multi-use developments are important to our state, important to the expansion of the tax digests in the counties that they're in, and of course provide many jobs and all the other economic benefits. So I would be glad to answer any questions about it.
All right, any questions from the committee? Representative Bruce, any questions or any other member online?
No, I'm good.
Okay. I know that we received some testimony in subcommittee on what I'd consider kind of a technical point about the subject matter that's being covered in this, and that came through Chairman Gunner's subcommittee. Mr. Chairman, anything you want to add, and did it receive a due pass recommendation?
It did receive a due pass recommendation. I have nothing to add to that.
All right. So receive due pass out of subcommittee, and I don't see any questions. Okay, well, I'll be happy to take a motion if there is one. Motion due pass by Chairman Scoggins. Is there a second? All right, motion due pass and second on House Bill 470 as introduced, LC 500157. Any amendments? Further discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Any opposed? All right, very good. It's on to Rules Committee. So we
Thank
will
you,
hear
Mr. Chairman and ladies and gentlemen of the committee.
Yes, sir. We'll go ahead and take up 480 when you're ready.
Thank you, Mr. Chairman. House Bill 480, LC 364642. This has to do with lien law, and it amends the code to allow or to add registered interior designers to the lien law. And that a registered interior designer must have an approved 4-year college degree and 2 years of work experience under another registered interior designer or architect. There are applications made and fees paid to the board of which they are registered. On the other hand, an interior designer, not a registered interior designer, can be anyone who gives themselves that title. What registered interior designers do is they submit drawings, they have a seal on their drawings, they work on some pretty complex structures with some things like dealing with petitions, doorways, et cetera. In other words, as just a point of explanation, it's much more than just what paint colors are used and those kinds of things. Often it is in big applications like for office design and those kind of things, and it can be a substantial amount of money involved. And so this bill just proposes that these folks be put on the same playing field as architects and other people who have the right to place a lien on something if they don't get paid. And so currently there are 23 states that contain lien law coverage for interior designer services. And so I think it's a good bill and a good addition, and out of a sense of fairness, I think these people should be allowed to be able to place a lien if they're not paid. And so I'll submit to any questions.
Yes, sir. Thank you. Any questions from the committee? Representative Walensky.
Thank you, Chair. You mentioned something about a registered interior designer, and I may have misunderstood, needing 4 years of college degree. Or can you just tell me again what you were saying when you said 4 years? Or
A registered interior designer must have an approved 4-year college degree and 2 years of work experience under another registered interior designer or architect. I am not sure what the degree has to be, but when application is made to become registered, then that is considered, and that is one of the requirements, that they have to have a 4-year degree.
okay. I'm just, so lines 34, 35 define registered interior designer, code section 4341 doesn't state that. And then it talks about code section 43430, I think it refers to. And yeah, in section 14 of that code section, I don't see it there either. I don't care, but I'm just, anyways.
Okay.
Yeah, may want to look into just that part. Thank you.
Does anybody from the committee need us to look into that further? Or okay, I'm not seeing any.
Yeah.
It's
No, it's so the location of the definition of registered interior designer is there. That's
Yeah.
what they're both in there, and it talks
it's the
about that.
4-year
It was
issue.
specifically with that. It's not an issue. I was just it's just when
understood.
it defines it. Yeah.
But if I understand your point, Representative Walensky, that won't necessarily change your view on the outcome of the bill. which-
Correct. It will not change my view, Chair.
Yep. Got a lot of folks looking things up right now on computers, so we'll just give everyone a minute to do that. That's okay. That's what committee's for. Representative Evans.
Thank you, Mr. Chairman. Representative Washburn, do you have any registered interior designers in your district that brought this to you? I was just curious how it got here.
No, that was not brought from anyone in my district.
Who brought it?
Lobbying firm. I don't know that I can give you all of the names. Brian, help me, my mind just don't blank.
No, I was curious the interest.
Of my interest in it. Well, actually, I do have an interest in it. When they brought me the bill, I felt like it was a good bill. I know of a case, not one of my constituents, but one of our colleagues who has an interior designer in his district who was owed $70,000. And he came to me immediately when I introduced the bill and said, could this be retroactive perhaps? And that's a legal question that I couldn't answer. And he said, I have a lady in my district who was owed $70,000 and this would really help her. So in response, I think it is a good bill. I'm in the real estate brokerage business. And of course, I'm not an attorney, but I do know if somebody's owed money, they can obviously file a lawsuit and get a judgment and cloud a title that way. But it takes a lot of time to do it. And this is designed for somebody who is owed money and needs to take some action to protect themselves in the short term to get a lien placed against the property to cloud the title so that they could have some way of trying to collect in a little faster way.
Thank you.
We'll call on Mr. Tolbert if he has anything to add about the question that's been raised about the requirements for this license status.
Yeah, the definition that the code section refers to, it refers to Article 2. And in Article 2, you have code section 43-4-32, and that lays out the age requirement and the educational requirement for a licensed architecture, a licensed interior designer.
All right, very good. Well, I think that was a helpful discussion. Now we're all on the same page with that. Any other questions? Representative Evans, any questions? All right. Any questions from any member online?
I'm good.
Okay. Representative Washburn, anything? Any final words?
I did want to clarify, I talked a lot about the commercial application here, which is where the numbers get bigger, but I do want to point out it is not just commercial. Certainly a registered interior designer who does residential work as well, which could also be a considerable amount of money, but I didn't want to leave the impression that it was all about just commercial interior designers. It's both.
Yes, sir.
Yeah.
All right. Well, I'll hear a motion if there is one. So motion do pass in a second. This is House Bill 480 is introduced, LC 364642. Any amendments, discussion? All right. Representative Bruce, anything?
No, thank you.
All right. All those in favor signify by saying aye.
Aye.
Any opposed? All right, very good. It's on to rules. And I'll note Representative Washburn has gotten 2 bills through judiciary without amendment here today. That is a rare feat. So you're on to rules, and please go ahead and fill out the rules committee form so we can get that signed today.
Okay, thank you so much, Mr. Chairman, ladies and gentlemen of the committee. I appreciate your consideration and your questions.
Thank you for being here. Yes, sir. All right, we will now move on to Representative Gunter's bill. We'll just take them in order. We'll take House Bill. That's out of order. We'll take House Bill 553. You're welcome to stay where you are or move, whichever you'd prefer. Okay.
You got me.
Yes, sir. Will you
House Bill-
test it real quick? Representative, will you tap on it? Yep, we're good. Thank you.
Okay, all right. House Bill 553. This was brought to me by the Chief Judge of the Administrative Law Judges. This is asking for them to be able to conduct hearings by remote communication. It also has in here a provision to allow for electronic filing. And I think they're going to make that a requirement of filing in their court. I did check with them. They do have the software to do that, so there won't be any additional cost. And that's basically all it does.
Very good. Thank you. Any questions from the committee? This was heard in subcommittee yesterday and received a due pass recommendation. All right, seeing none. There's a motion to pass by Chairman Oliver. Is there a second? Or a motion and a second. Any discussion, questions? All right, hearing none. All those in favor signify by saying aye.
Aye.
Any opposed? All right, House Bill 553 passes unanimous. It's on to rules.
All right, I'll get the form before we get out of here.
Yes, sir. Yeah, and when you're ready, we'll proceed with House Bill 554. This is a substitute, LC 413023S.
Yes, and this is making a change in our Liz Pendon's law to allow for more courtroom or court judge control. We heard testimony from a gentleman who had been in a lawsuit that messed up his, he was a developer of real estate, and he had a big project going, and it messed him up. So what we have in here is that the party claiming to or wanting to claim against somebody, and they want to file a Liz Pendens, they have to, let's see. We made a change and I'm trying to remember what it was. Oh yeah, in domestic cases. Now, yeah, the idea behind this, and that was brought up, that this would not apply in domestic cases. And that's the reason that we have the committee sub. And what I'm looking at is LC 413023S. But as the way it works is the person wants to file a Liz Pendens, the other party can object. They would hold a hearing. The judge can leave it on or take it off at his discretion. And later into the lawsuit, if it becomes clear that the Liz Pendens is no longer needed, the judge sua sponte can take it off. So, and then as for domestics, we would continue under the same law that we have now in domestic cases, and that's basically what the addition says.
No, in subcommittee, we heard testimony that a Liz Pendens can have the effect of a lien, and can
Right.
hold up big real estate transactions and things like that taking place potentially inappropriately when it's being misused.
Right. They
So,
won't write the title insurance. So
yes, sir.
it has the same effect.
All right. Any questions for Chairman Gunner? What's your number, Representative Oliver?
10.
Okay.
Where exactly is the fix in relation to domestic relations?
I was afraid you were going to ask that.
So it's lines 14 and 15.
It says shall only apply to actions involving any matter.
So that's the existing law that follows that. So in other words, that remains unchanged. Existing law continues to apply for cases under Title 19.
Gotcha. Thank you. I understand the,
Right,
I understand the fix now. Thank you.
Okay.
I was confused.
Yep.
Mr. Chair.
Yes, Representative Dreyer.
Yeah, thank you, Mr. Chair. Representative Gunter, I appreciate the desire for this, and I've dealt with Liz Pendens quite a bit, but in my mind, I was always extremely careful with adding a Liz Pendens because I could be opened up to slander on title, and then those damages could just be, astronomical in a situation like that. I mean, I guess I end up using a Liz Pendens with real estate litigation every year or so because it does give so much protection. And I know you're still allowing a judge to look at this, but in my mind, that slander on title is just such a heavy hammer that I'm used to people vetting that fairly well before filing one.
I appreciate that. And you are an ethical attorney that wouldn't violate that. I think we have attorneys around the state or individuals that file lawsuits that would automatically file their Liz Pendens to do damage and do exactly what you're talking about, slander the title.
I think that right, but Judge, in your experience, don't people typically bring a slander on title claim and then open up potentially the lawyer and the client to tort damages?
I'm sure they do. In my career, I've never run across it.
Okay.
And I'll just add in, I felt like because I asked a question along these lines in subcommittee, I feel like the circumstances sometimes arise where there is it would seem clear that there is not a question as to the property where this is filed is at issue, but because maybe the ownership by one of the parties individually, as opposed to one of the, maybe the companies that's involved in the dispute, there's arguably the ability to file it with a straight face, but where everyone knows that ultimately when you get to court, a judge is going to say, no, it needs to come off. It's just the problem is the burden is on the property owner to seek that hearing before a judge. And that can take months and can be quite a bit of work. And you'll see here, Representative Dreyer, and forgive me if you heard this in subcommittee, I'm kind of rehashing what was discussed there, but the concept, as I understand it, is you'd file your claim, you file your complaint, and along with it, you'd file a motion for lis pendens. And if there's no objection, the court would be able to issue it within 10 days or after 10 days if no objections filed. So it would ultimately have a similar effect to what's currently happening is the thinking. It's just if judicial review is necessary, it takes place at the front end rather than when there are issues later.
Yeah, thanks, Mr. Chair. I mean, it is pretty broad power just to be able to go file one of those things on the record. Okay, thank you.
Yes, sir. Thank you. Good question.
Yeah.
Any other questions?
I will say that any of the lis pendens I dealt with as a judge came on the back end after the case had been filed and litigated.
All right. I don't see any other questions. So at this point in time, we will I'll hear a motion. All right. There's a motion due pass by Chairman Oliver. Is there a second? All right. This is HB 554 substitute LC 413023S. Any amendments, further discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Any opposed? All right, the bill passes unanimous. It's on to rules. All right, we have two other representatives who are presenting bills in other committees and are coming here as soon as they can. So we have a bill that is being reviewed for the first time by Judiciary next. It's Representative Leverett's HB 635. So Representative Leverett, you can present your bill from where you are and proceed when you're ready.
Thank you, Mr. Chairman. I think we have a few witnesses to talk on this bill who can, I think, talk from much more of a practical, hands-on experience perspective. So I'll just briefly touch on the purpose of the bill. The purpose of the bill addresses the ability of judges to execute orders and perform other judicial acts remotely from their chambers or from courthouses. Right now, they currently can do that anywhere within the geographic limits of the state, but they can't always do it when they're outside the state. So this doesn't expand their jurisdiction. It just allows them to do the same thing they could do from Sapelo Island or Cumberland Island that they currently right now can't do if they're at Amelia Island in Florida. This would just allow them to be able to sign those orders, sign warrants, sign other things of that nature in remote circumstances where they're hearing a case remotely. Being a small town lawyer, the scenario that I currently don't do much domestic work, but traditionally you would have a situation where your divorce client has already rescheduled a new wedding before they've gotten divorced and they're desperate to get the decree signed. And so this would allow the judge to still sign that uncontested divorce decree, even if they were in Amelia Island or Charleston or just north of the border in Tennessee. So that order could get entered and filed, and the litigants wouldn't have to wait until the judge was back in the jurisdiction. There also is a section and so the reason for the number of sections, Mr. Chairman, is that we're trying to make the fix in various code sections that currently require physical location in the state. So there's one section that's to do with superior courts, and one section does with state courts, and a few sections deal with magistrate courts and so on. And then there's also a final section that deals with alternative locations for actually holding court within the vicinity of the courthouse, but in a different location if necessitated by emergency conditions. And there's a requirement that the governing authority approve it, that the court be open, accessible, And there's also a provision dealing with state courts and that sort of thing. So it's, I think, something that the judges have indicated as a concern that they would like to be able to have passed so they can better, more effectively and efficiently, deal with their cases on their dockets.
All right. Thank you, Representative. Any questions for Representative Leverett? Representative Oliver.
I can think of a number of cases where courthouses have been moved, fires, destruction. Are you suggesting they didn't have the authority to open up the court in the double wide in Forsyth County when the courthouse was burned down?
I think I will let some of the other witnesses talk to that issue because they're probably more, have greater knowledge and expertise than I do on that, Madam Chairman.
Thank you.
And I'm glad, I don't know when to step in, Chairman.
Yeah, please, Judge Goslin, thank you for being with us today, and please go ahead.
Okay, thank you. I'm really excited about the bills, and Chairman Oliver's question is part 2. That section was rewritten. There was a law about how to develop and how to designate an alternative location before. This is an update of that we found out during the pandemic. Part of the problem was that it said some things like the building had to be in the county seat. Well, for instance, we couldn't find anything in our county seat that was acceptable. The county had to own the building. This says they can own the building or have a contract with the group that has the building. So it updates it to give us some more flexibility, is what it does.
All right.
Thank you, Judge, for rescuing me on that question.
Absolutely. And I'm glad to speak on all we are in favor of the bill, both as a member of the Council of Superior Court Judges Legislative Support Team for the first part, and the second part, I'm here. It was part of the COVID task force. So it's a wonderful bill. Thank you, Representative Leverett.
And Judge, just my understanding was along the lines of what you just described, the Council of Superior Court judges supporting the first part of the bill. The second part is the Judicial Council in a response to COVID-19. Is that right?
Yeah, exactly.
Yes, ma'am. Thank you. Representative Oliver, any other questions for Representative Leverett or Judge Goslin?
I also think this is a very helpful. It's not so much that the judge can go to his or her vacation home, but that there's business that takes you out of the state, out of the county, whatever. So this will help judges get work done that needs to be done. So
absolutely.
Representative Evans.
Thank you, Mr. Chairman. Thank you for the bill. I like it a lot. I think it's going to be really helpful. On part 2, though, are we intending to limit where these alternative sites could be to inside the county or inside the circuit, I guess, if it's a multi-county circuit? I want to make sure we're not going to be forcing people to travel far away from where they are to seek or participate in the justice process. And it may be in there and I'm just not seeing it.
I don't think it changes what was there, and we always had to be in the county. I'm not sure I can point to it right now, Representative Evans, but the governing authority of the county has to approve the site. And the county has to either own the facility or have a contractual relationship with the facility.
I think that's just for the criminal jury trials, though, section.
That is criminal, yeah.
146. Well, if that's the intention, I mean, I'm sure we can put some language in here, but I just wanted to check before I started looking for some words.
What I'll do is I'll ask Judge Kell if he'd be willing to come forward and join us. And Judge Kell, what we've been discussing is requirements for, that's fine if you'll just tell me the number, what requirements there would be in place as to where court could be held under this bill if there were to be an alternate location. What? 14, yes, sir. Thank you. Go ahead.
Thank you, Mr. Chairman. I appreciate the members of the committee considering this bill. The limitations in the bill with respect to that essentially are that the governing body of the county would have to approve the location before it could be approved. That was one of the safeguards placed in there. understand one of the reasons that there wasn't a geographic limitation. Representative Oliver, and I forget who asked the question a moment ago. Yeah, that is because, for example, one of the scenarios that was brought to us is if you're in a rural county, and let's say in a neighboring county, there is a state court or another court building that would be appropriate to hold court that's geographically desirable. In other words, your people in your county wouldn't have to travel outside the circuit or very far to get there. The county might actually be able to approve within that circuit or in a neighboring county a facility that is appropriate. Because I mean, I'm lucky in my jurisdiction, we have a civic center that's a mile from the courthouse. We've got some gymnasiums and other things that we could use. There are a lot of jurisdictions that wouldn't necessarily have the availability of those kinds of places. And so the idea was we don't want to limit it because we might be hurting some of the circuits that might actually need it the most in order to use it. So if you're close to, Tifton and ABAC is close by and there's an appropriate facility there, but that's not within your county's jurisdiction, you might be able to use that. Again, most of this is things that came up during the COVID emergency so that we could try to find facilities that are big enough to do things like select a jury. So if we needed to be able to put 60 people in the same room, 6 feet apart, even my jury assembly room won't accommodate that. And a lot of facilities in a lot of counties won't either. Did that answer the question? I didn't hear it all when I was out in the hallway, so I apologize for that.
No, that's very helpful. My concern though is that if we're making people travel too far, and I don't have the language in front of me, but somebody in this room might know, we put a limit on how far we make people travel for subpoenas. I mean, it just feels like we should limit it within that same miles because not everybody has access to jump in their car and drive.
Well, actually, the limit, and not to correct you, but the limitation with respect to subpoenas is we make them travel a certain distance without being paid, and then if we make them travel further than that, we have to pay them the mileage to get them there. So, the idea with having the county governing body be the one that's allowed to select this rather than the court is that you would have somebody who's accountable to those people within their own jurisdiction who would make the approval of that location, rather than the Superior Court saying, well, it's convenient for me to have it, in this neighboring jurisdiction. And, if my constituents have to drive, but I totally understand what you're saying. The other good limitation on that is we also have to be elected as well. So hopefully that puts some limitations on the judges to not inconvenience the people within our own jurisdictions
Well, I suspect the folks that are going to be potentially in the worst spot are not going to be the ones with the biggest political clout in the county, just to be honest.
No, I understand. I understand what you're saying. I wasn't being facetious, but I mean, we're answerable to those, hopefully that same constituency, and would take that certainly into consideration.
Do you know the answer to my question though about the miles? Before you have to be paid, do you know what that is, or does anybody know what that is?
I don't. I want to say 25 miles. Is that stands? Is that what it is?
That seems like a reasonable limitation to me. I'm just really worried about what people might not. I think people that are in tables and rooms like this, we don't think about those things. And we, as good-hearted and well-intentioned as we are, sometimes we just don't think about it. Just even, well, it's a nicer facility, it's bigger. Well, that's great. But if it's 50 miles and we're asking people to come there to get access to justice, then I don't think we're doing anybody any favors. And I just think we should be really cognizant of that and make sure it's in the law, because our job is to legislate for the worst case scenario and not when everybody's doing the right thing and acting with everything goes right. That's my biggest concern.
Can I step in, Judge Cal? Sorry, I know you're in there.
Please, you've dealt with the bill even more than I, so thank you.
Yeah, so one of the things that I would hate to do a mileage limitation, but if Representative Evans wants to discuss, within the county, the circuit, or an adjoining county, maybe that would address the concerns that you have. If you put miles on it, the counties are all so different in this state. And, for instance, Judge Kelly down in St. Simons in that area, I mean, he travels 2 hours to get to different courthouses. And so I don't know the length of one of those counties. There are counties that are huge, so in rural areas. So I don't know that a mileage limitation would be helpful for those areas. And they probably have the least amount of facilities that could be an alternative.
Any follow-up, Representative Evans? Okay, Chairman Oliver.
I wanted to follow up to Representative Evans' question. You know, in our big counties, you and me and Judge Kell and Judge Gosselin, all of our big counties are going to have, what I see them doing is putting them in strip malls. I've seen a lot of temporary courts in strip, and there are a lot of empty strip malls. The real question in my mind that you have triggered me to think about is the circuits that have many, many different counties. And what are the options in a 6-county judicial circuit? If we limit it to judicial circuits, that might be the only reasonable way to think about it. Might be a little helpful, although it'd be further in some judicial circuits to go to the far end than it would be to go next door to Macon, Georgia, that would have a bigger facility. It's the kind of the logistics of how you define it. But none of where we put the courthouse changes anything in this bill. This is my question to the sponsor. Changes anything about where the jury pool comes from, does it?
Oh.
So the jury pool, even if your courthouse is in the strip mall in this adjoining county, the jury pool is going to come from the county. Am I correct? Is that what?
Yes, ma'am. Yes, ma'am.
Absolutely.
Okay.
Well, and to that question, if I may say, Mr. Chairman, I would
Yes,
think
please.
that limitation would also, just as a practical matter, limit the extent to which the county governing authority or the court would be willing to move the court. As sort of the only well, I've got another freshman in the room who's got much more experience in matters of court than I do. I don't know if the judges would be opposed to any kind of limitation that would limit it to the judicial circuit in which the court is held or an adjoining circuit, or if you're concerned that would further restrict the whole reason you're modifying the code section.
In fact, if I may, Mr.
Please.
Chair,
Please.
the big counties, the DeKalb circuit, the Hall circuit, you've got other counties, but I mean the Gwinnett, Cobb, we're going to have facilities. And Hall, and you still have Dawson. I was going to say Lumpkin, but it's Dawson. You have facilities. If we limited it to, this is a question maybe to Representative Evans, if we limited it to the judicial circuit, does that really help?
No, and I don't know that it does. I'm just trying to figure out something that is reasonable so that, because I think I'm right, and y'all can correct me if I'm wrong, but the judges hop around the circuits because we don't want to make the people go to a courthouse on the other side of the circuit. They go to the courthouse in their county and the judge travels to them. Here we could be asking people to do what the judges do, drive 2 hours. And I just think that's not a reasonable thing for us to ask people to do.
I just don't know what the option is, though, if the courthouse is burned down, which is what this issue doesn't come to me in COVID context. It comes to me in terms of the multiple courthouses that I go to. They're burned down.
We have a lineup of questions right now. I'm just going to take them in order. Representative Dreyer first online.
Yeah, thank you, Mr. Chair. The subpoena language does say anywhere within the county. You don't have to pay anyone. Beyond that, it's 30 miles. But I think I hate to mess with the bill, which has got a great intent and we probably need, but I think it does address what Representative Evans brought up first and Representative Oliver's just mentioning. If it's possible to limit it within the county, that should be a fairly reasonable balance to strike that would mirror what we've already done in various places in the Georgia Code and the way the courts are set up.
Thank you. Representative Gunter.
Thank you, Mr. Chairman. I did have an instance in a criminal case where we had to move out of the courthouse and go to another location. And it wasn't approved and the case got reversed based on that. The location that we went to, though, and this was in a criminal case, and I do have a concern in here that Towns County is a very small county, doesn't have a lot of assets, and we had to go to a facility, a church across the street that had the room that we needed. But under this bill, that wouldn't be an option. We would have to find some other building that the county had an interest in. That's my only concern about that.
Well, unless they leased the Family Life Center or wherever it was held, I think that would be permitted if I'm reading the bill correctly.
Absolutely. Yeah, they can have a contract with the facility. Yes.
Yeah. Well, our situation arose rather quickly and
Yeah.
there wasn't a contractual relationship.
So, so that language was added in here. You look at 147. This issue was debated in subcommittee previously. It's made clear that it's either owns the facility or has a contractual relationship. So, if one hypothetical is the courthouse, or rather the county contracts with a private business or organization or something like that, the whole court there. Another possibility is there's a government building that's available, then be possible to utilize that building. And also we added in the Americans with Disabilities Act language to make sure there's accessibility to the facility, whatever the facility is that's selected. All right, Representative Rich.
Thank you. It seems to me that we already have some restrictions about the locations that can be selected. And with a state like ours, where we do have counties with such varying sizes and circuits, that we already have addressed the issue where the governing authority for the county or counties have to select a location that they find is in the best interest of the public. So it seems to me that we already have something to address these distance issues. And it would be much more difficult to prescribe a certain mileage given the differences between all of our counties. That's on line 138.
Chairman Oliver.
I'm really thinking that an amendment, I'm just thinking aloud, what would be the solution, is to limit it to the county. And if it's a poor county, I have been to court in double wides, and I have been to court in strip malls. And if the county has no other option, a very, very small county, than to put up a double wide, so be it. That may be the best solution.
It's not just small counties. Could be large counties that are growing very fast as well and don't have the space as well. Yes, Judge Goslin, please.
I hate to belabor the point, and the COVID task force and the Judicial Council are open to whatever language, obviously, that the committee thinks is appropriate. If you limit it to in a small county where they just have a double wide, for instance, as Representative Oliver just said, you don't deal with the COVID issue. And I know this is intended to deal with all sorts of issues, courthouse burning down, whatever, but COVID requires us to, the reason this has been such a problem was we had to find such big buildings, and Judge Kell mentioned that, because we're trying to do everything with everybody socially distanced, and to have the number of folks that you need to have to bring in for a jury is just, it's staggering in trying to figure the logistics out. So you can't just throw up a double wide or rent one for this specific problem. So I'm a little concerned about those counties. But whatever y'all decide is fine. As long as we have some flexibility, which is what we didn't have before, I think we'll be fine with updating the language however you approve it.
And Mr. Chairman, if I could just add one thing to what Judge Goslin, Goslin said, a perfect example of the scenario that she's talking about is recently during one of the windows that we had where we could have jury trials if the numbers were appropriate, the Augusta Judicial Circuit, which is not one of our small rural circuits, but they had a murder trial during one of those periods of time, but they could not pick a jury in the courthouse because they didn't have a room that was large enough to socially distance enough jurors to pick. And they actually moved that trial to the Civic Center to have a facility big enough to space all the jurors out. And they held the entire trial at the Civic Center in Augusta because their courthouse simply wouldn't accommodate that trial during COVID.
All right, Representative Leverett.
Mr. Chairman, I'm just trying to see if there may be a way to deal with the issue and deal with it somewhat promptly, giving the time restrictions I, as a freshman, understand that sometimes apply around here. Representative Evans, might it satisfy your concern and the judges if we had some language just requiring that the governing authority or the court take into consideration the distance of the proposed location from the county seat? because I'm concerned, like being from Elberton, we could pick like the First Baptist Church Family Life Center and we could all socially distance. But if they were concerned about, and as I understand the statute, we don't have to have a pre-existing contractual relationship. We just need to sign a lease, when we need it.
Exactly.
But if they feel like that creates sort of a church and state entanglement, that is the deacons, and we have to go outside that area, I'm not really sure where we could use. I mean, we could perhaps use a gymnasium, but that may not really be suitable for sequestering panels of juries, and we might need to go outside the county. And so I think it's difficult to come up with a one size fits all sort of hardline rule here. And I'm just throwing that out if that might be. I appreciate the concern, because a lot of folks in my circuit, it'd be tough for them to drive, 30 or 40 minutes for court. I mean, they can't get the time off work and they'd have it difficult. But rather than mandating a specific distance or location, if we just require that to be taken into consideration, because I personally feel like my judges are gonna view as paramount. They're elected. They're going to view as paramount juror convenience, witness convenience, parties convenience, and the governing authority would too.
So what we'll do is we got a few more questions. We'll go around. If anybody's working on language, you can kind of be working on that right now if that's where this is headed, and we can hear that at the appropriate time. Chairman Scoggins. Oh, you didn't have a question. Sorry. Representative Gunner.
Thank you, Mr. Chairman. I had an online judge give me a suggestion. Limit it to the county or adjoining county. That way you don't worry about circuit lines, but whatever's the most convenient, either within the county or to the adjoining county.
All right. So what we'll do is we'll have a discussion at the appropriate time about what the potential concept is, and maybe work to get that nailed down, and then we'll go ahead and take up language that we might consider. Any other questions for Representative Leverett, Judge Goslin, Judge Kell? Any online? I don't see any. All right, very good. So I'll consider a motion if there is one. So there's a motion to pass on House Bill 635 is introduced, LC 413010. Is there a second? Or is a motion and a second? All right. So what we'll do now is we'll kind of go around the room for any discussion as to amendments or specific proposed amendments. And if you have an amendment, you can go ahead and make that a motion, and we'll hear that just in the interest of time to see if we can nail down what that proposal might be. Representative Evans.
Thank you, Mr. Chairman. I think I have something that's simple enough. It would be, I'll just talk it out for a second, and then we can go with the lines. But on line 140, just having adding some language in there that it would basically read, no such court may be held at any place that is outside the county or an adjoining county, or that is, and then it would continue that sentence. But I do also like the idea of adding some language in for the county governing authority to consider, maybe in somewhere around 137 or 138, by appropriate resolution deemed would be in the best interest of the public, with considerations for transportation burdens being paramount, something like that.
Why don't we take those separately?
Mhm.
Are there, this is a little informal right now, but are there any other amendments over the same subject matter so we can compare those? Any online? All right, I don't see any. So we'll take the Evans amendments separately. So the first amendment is on line 40. As I understand the amendment, it is
140.
Yes, I'm sorry, 140. Thank you. After the word
Is.
Okay, I thought it was after not. Why don't you say it for me one more time?
On lines 140, between the words is and not, insert outside the county or an adjoining county, or that is.
Doesn't work.
So then it would read, no such court may be held at any place that is outside the county or an adjoining county, or that is not open to and accessible by the public.
All right. There's a motion and second. The amendment is, line will read, no such court may be held at any place that is outside the county or an adjoining county, or that is not open to and accessible by thee. There's a motion and second. Any discussion? All right. Any objections to the Evans amendment? Hearing none, it's adopted. All right. Let's hear the second amendment, please.
Thank you, Mr. Chairman. On line 138, after the word public and before the semicolon, with considerations for transportation burden being paramount.
Okay. Second Evans amendment is on line 38 after the word public, 138, after the word public and before the semicolon, with considerations for transportation burden being paramount.
Yes.
Or is there a second? All right, motion is second. Any discussion? Any objection to the second Evans amendment? Hearing none, it's adopted. Any other amendments from the committee for the bill? All right, hearing none, we'll now consider House Bill 635 as amended here today. All those in favor signify by saying aye. Aye. Any opposed? All right, it passes on to rules. Thank you.
Thank you very much, Mr. Chairman and committee.
Thank you, Judge. Thank you, Judge Goslin.
You're welcome.
All right, we have, we are not going to be hearing House Bill 358 today. But we, so just for your planning, we have one final bill on the agenda. Representative LaRicchia, if you'd like to come forward, please, sir, and you're welcome to bring anyone with you if you want, if necessary, just as you choose. And when you're ready, we will hear you on House Bill 536.
Thank you, Mr. Chairman. Thank you, members of the committee. We bring House Bill 536, LC number 345742 EC. And, you know, I've read this thing 4 or 5 times, and I guess I left this out in the subcommittee, but this is under the governor's emergency powers section, which is the 38351. This just adds K to that after J in those emergency powers. It says no power granted under this provision of the code section shall be utilized to specifically limit the practice of any religion. And as you know, we have had across the country, we've had several concerns about the way that different states were handling this global pandemic, which everybody was really doing the best they could. But there were unintended consequences of some of these guidelines and these shutdowns. And one that raised a serious concern to the governor was to prohibit faith practices. And so that's what this does, Mr. Chairman and members of the committee. It's very specific in how it is written with that word specifically. It just said basically faith practices can't be targeted, but if there is a broad shutdown of any kind for a pause in the activity because of something like we've just encountered, then faith practices would be included as far as a broad type of a shutdown, but they could not be specifically targeted. And so, Mr. Chairman, I'd appreciate your favorable consideration.
Thank you for your presentation, Representative. This came out of the Scoggins subcommittee. Chairman Scoggins, any report you want to give on the bill?
This was voted out unanimously, and I think it's a great bill, and I hope it passes.
Yes, sir. Thank you. All right, very good. Any questions for Chairman Leader LaRicchia? Yes, Representative Oliver.
I'm sure this is because of my ignorance about the governor's emergency bill as it existed, because I haven't spent any time with this. But what you're adding to, the governor cannot exercise his power to limit a practice of any religion. That's what you're saying.
No, ma'am, to specifically target faith practices. There could still be a circumstance by which faith practices could be impacted, but that would only be during the time where there was a broad shutdown of everything. Like, we could have never imagined, 14, 16 months ago, that we would have to literally shut down activity to try to figure out what the necessary steps and guidelines would be to prohibit the transmission of COVID-19. So when it's a broad shutdown, faith practices would be prohibited or limited, but it would not allow someone to specifically target faith practices. And you may be familiar with the Hasidic Jewish community and their fight against Governor Cuomo, of which they won in the Supreme Court because it specifically prohibited their traditions of faith practice within the Hasidic Jewish community.
So if the governor's powers say no church can operate a daycare center, period, then that is he could do that. But he could not say the Episcopal Church on West Peachtree can't operate its daycare center. Is that the purpose of your?
Yes, ma'am. I apologize. The mask was kind of muffled. I think I understood what you were saying, but it would be more broad even than that. If the governor just says, hey, we're on a temporary pause from businesses, organizations, schools, like we paused our schools for a period of time, that would include and encompass pretty much everyone. When they open back up and they start to see little pockets like we saw in funerals or church services, there would not be, under this particular prohibition of those powers, you wouldn't be able to specifically say no churches, or no faith practices. And so I'm not sure if that addressed the scenario that you presented.
Well, it keeps the question alive in my mind. You're saying the governor cannot say there shall be no funerals inside a building?
No, ma'am.
He
The
cannot
word
say that.
specifically just says that the governor, under the emergency powers, could not specifically target faith practices. Specifically.
But what you're saying is the governor could not say there shall be no funerals in the Baptist church.
If that is considered a faith practice, and that may be a question for a court.
Well, the faith practice is what's got me hung up, because my daycare center in my church has faith practices. They pray. Funerals are faith practices.
Then your scenario
camps
would be correct.
Day camps are faith-based day camps.
Mm-hmm.
So, again, I'm sure my confusion comes from the governor's emergency order, that statute, which I don't understand completely. I haven't studied it. And do we have any?
Well, I mean, your scenario would be correct. The governor would not be able to say that.
And Representative Lurker, can you give me any example in Georgia in our last year of emergency orders where the governor has taken an action where this statute would violate it? Would not allow him to do it? Not this
particular governor, and not in this state, but a lot of the things that we address would be proactive because of the number of issues that have arisen across the country as it relates to this, and just making sure that there is an additional protection for the First Amendment in this state under emergency powers.
And that's what I think your bill is about. I think your bill is about me saying that my church on West Peachtree will not be covered by the governor's order because I'm exercising a faith practice at my church on West Peachtree. That's what the purpose of the bill is.
Ma'am, would you mind introducing yourself, and the committee would like to hear?
I'm Lauren Veneta. I'm Associate Executive Counsel with Governor Kemp's office. I think some of the concerns is we are trying, if there's a shutdown of daycares, it's going to be a broad shutdown. We're not going to shut down one daycare because it's at a church. It's going to be across the board daycare shutdown. We don't have any specific examples. This is following Supreme Court, what came out of the Supreme Court, and we want to make sure that for future crisis that faith practices can continue in Georgia.
We have a question online from Representative Wilson.
Thank you, Mr. Chairman. Mr. Floor Leader, I certainly sympathize with the concern here, but how is this not already protected by the First Amendment? And hasn't the Supreme Court already ruled that the First Amendment covers this?
In the instance of the Hasidic Jewish community and the state of New York or Governor Cuomo, they have, but there would be a situation where the guidelines would still be in effect and perhaps prohibit some faith practices, either because the size of the building, because of the number of people involved, and there would not be a way to comply with those particular guidelines. And so that would be a broad sort of an issue for them to continue with faith practices, where what this would prevent is more of a specific targeting of faith practices, where you would leave the Costco's and Best Buys open, you leave the mall open, and all of a sudden there's something narrowly written to prohibit faith practices. And so I'm not sure if that.
Well, but don't and I appreciate you highlighting that case. I'm thinking more about the South Bay United Pentecostal v. Newsom case, the California case, where the Supreme Court basically said that these, exactly what this bill gets at is that these executive orders can't specifically limit church practices because it doesn't survive strict scrutiny. It doesn't, under the First Amendment, if religion is the target of the action, the state actor has to show that first, there's a compelling state interest for the action, and that it's the least restrictive means of achieving the desired outcome, which the Supreme Court has said you can't meet that burden with these executive orders for this reason. Because why target churches when like we've talked about, you can issue a broader, instead of just saying churches can't have more than 10 people in attendance, saying no groups larger than 10 people. It includes groups outside of churches. So what I'm getting at is I think this is duplicative of what's already covered by the First Amendment. And given the concerns we have about the interpretation of the word specifically and religious practices, I'm reticent to support this.
Representative Jones.
Thank you very much, Mr. Chairman. To my respect, to my colleague, Representative Wilson, who I believe to be a more learned jurist than I am, I believe there is conflict amongst SCOTUS. When you look at SCOTUS to Calvary opinion, Calvary Chapel, Dayton Valley versus the governor of Nevada, we saw that it was a slightly different interpretation in terms of, I'll say, emergency powers, in terms of what the state of Nevada did in terms of opening up, I'll say, casinos, multiplexes, et cetera, but not opening up religious facilities. So again, I would say I don't disagree with Representative Wilson. I would just say that I think it is a bit muddy right now, and I think providing a little bit of clarification would be helpful.
All right, any other questions? Any member online have a question? I don't see any others. So at this point in time, I'll hear a motion if there is one.
Motion to pass.
All right, there's a motion to pass on House Bill 536 as introduced, LC 345742EC. Is there a second? The motion is second. All right. Any amendments, further discussion from the committee? All right, hearing none. All those in favor signify by saying aye. And members online, in the affirmative?
Aye.
Okay. All those opposed? All right, we'll go ahead and do a hand vote. All those in favor signify by raising your hand. You just hold them up so we can get the count. All right. All those online in the affirmative, please say your last name.
Holcomb, aye.
All right. All those opposed in the room, please raise your hand. All right. All those on Zoom, please state your opposition by saying your last name.
Wilson.
Dryer.
Bruce.
Bill passes 6-5. It's on to rules. So that is our final bill for today. So we are adjourned. Thank you, members.
Chairman.